Shri Radhey, Exercise 19, Legal, Dictation, 80 words, a minute, Para 3, Ready. He denies the submission of the counsel that the respondent never contested the petitioner's interpretation as set out in the petitioner's email. According to him, it was the petitioner's own understanding that the lock-in period was ending on May 14, 2020 and had not yet expired by April 4, 2020, otherwise faced with potential termination. The petitioner would have specifically asserted at this stage that the lock-in period ought to commence from the opening date and not from May 15, 2015. The petitioner did not do so at all. He also highlights the fact that the submission of Mr. Dutt that breach must occur after the lock-in period is over as per the counsel as flawed, because by that analogy the lock-in period would stand extended till July 2025. That implies that the lock-in period is 10 years from effective date and 8 years from opening date. This is not and cannot be the intention of the parties when the lock-in period is of only 5 years. Without prejudice, and in any event, final counsel submitted an alleged negative covenant ought not to be enforced after the effective date of the termination notice. In this regard, he has relied upon the judgment in the case of Royal Orchid Hotels Limited v. Modern Hotels Private Limited. Learned counsel submitted that the petitioner was only managing and operating the hotel of the respondent as an agent and licensee under the agreement.